Canadian Legal, Government and Court System, Chapter 16. So, what does it say? I'll give you the basic concept and the general idea. After getting my idea, after understanding the term, you must read the chapter one time. Or if you don't understand, again read it. You have to understand what does it say, what does it mean. So to understand the government power, this chapter provides an overview of the Canadian state and legal system, focusing on constitutionalism, federalism, and Canadian Charter of Right and Freedom, parliamentary democracy, lawmaking, and the structure of Canada government and justice system. It explains the division of power between federal and provincial government, the role of judiciary, and the importance of the rule of law. And this chapter also delves into the Canadian court system, including provincial and federal courts, administrative tribunals, and the Supreme Court of Canada as the final arbitrator of the legal dispute. Supreme Court is the biggest. So I'll explain the key points of this chapter in a simple English to make you understand what does it says. Rule of law that applies to everyone including the government. For example, if a police officer breaks the law, they can be taken into the court for the justice like everyone else. They are not above the law. Constitution. Constitution is the supreme law. It's made up of written laws like a Constitution Act and unwritten tradition like the role of Prime Minister. If a law conflicts with the Constitution and if it's conflicting, then the Constitution prevails and it can be struck down by the court because it is conflicting with the Constitution, and Constitution is the supreme law, and the law is not valid if it is just conflicting. So, Charter of Right and Freedom. These rights protect the individual rights like freedom of speech, religion. For example, if a law unfairly restricts free speech, a court can declare it invalid. Now, if it is conflicting with the Charter of Right, the court will give you decision in your favor because it is against the Charter of Right. Parliamentary democracy. Canada government is led by the elected representatives. Elected, not selected. Keep in mind. And the Prime Minister is the leader of the party who wins most seats in the Parliament. For example, if the Prime Minister loses support in a Parliament, they may have to resign. Now the courts and tribunals. Canada has provincial courts like Ontario Court of Justice (OCJ), Federal Court of Canada. The Supreme Court of Canada is the highest court and make final decision on a legal dispute. So public law versus private law, they are two different terms. Public law is quite different and the private law is quite different. What is the difference? Public law deals with the government action. When the public is involved, the government is involved. And that is criminal cases, because in criminal cases, Crown is fighting against the criminal, while the private law is a private. It deals with the dispute between individuals, like a contract dispute, a divorce, and some other things. And third thing is criminal law versus civil law. Criminal law involves crimes like theft, while civil law involves dispute like property or contract. So criminal is like crime involved theft, robbery, murder. These are the criminal cases. As far as the civil law concerned, it involves property contract. For example, it might be case then you have to put someone in jail, while civil cases might require them to pay the money. So in criminal, you might go in jail, but in civil, you might have to pay the fine or some money matters. Now I'll explain separately what's public law, criminal law, and other terms. So public law meaning the law that involves the government and its actions, like criminal law or constitutional law. Example, criminal cases where the government prosecutes someone for breaking the law, whereas the private law meaning the law that deals with the dispute between individuals or organization. Private, individual or organization, like contract or property dispute. For example, lawsuit between two neighbors over a property or boundary. And again, the criminal law meaning that law that deal with the crime like theft or assault, punish offender. If someone steals a car, they can be charged under criminal law and face jail time. In civil law, the law that deal with the dispute between people or organization, often involving money or property. For example, lawsuit where someone sues for the damage after a car accident, civil law. So now the delegated legislation meaning law made by the authorities like municipalities under the authority of the Act of Parliament. They are working under the Act of the Parliament or provincial legislator. So if city passes a law, a bylaw about parking rules under the authority of provincial law, that's a provincial law. And the royal assent. Royal assent meaning the final step for a bill to become law, where the king's, now it's queen, representative, now it's king, representative, governor general, lieutenant governor approves it. Royal assent is the final step for bill to become law, where the king representative, who are they? They are governor general or lieutenant governor, approve it. Example, after parliament passes a bill, governor general sign it to make the law. Otherwise, it is not the law unless it is signed by the governor general or lieutenant governor. Judicial independence. That means the judges make decision without interference from the government or others. That is judicial independence. Example, the judge decide a case based on the law, not because the government wants a certain outcome. So judge is free from everyone to make his decision based on the laws. Supreme Court of Canada. Supreme Court of Canada meaning the highest court in Canada that make final decision on the legal dispute. After that decision, no more decision. Example, two provinces disagree about the law. The Supreme Court can decide who is right. That is final. Done. Administrative tribunal meaning. Administrative tribunal is a body that decides disputes under specific laws like human right or labor dispute. For example, human right tribunal decide if someone was discriminated against at work. That's the tribunal will decide what to do. So now the term notwithstanding clause. Notwithstanding clause meaning a part of the charter that allows government to override certain rights temporarily. Example, the province passes a law limiting free speech using the notwithstanding clause to bypass the charter. So that notwithstanding is a temporary override rights, notwithstanding clause. Responsible government. Responsible government meaning the government must have the support of majority in the parliament to stay in power. The government must have support to stay in the parliament. That's a responsible government. For example, if the prime minister loses vote of confidence, they must resign or call an election. Balance of probability. Balance of probability meaning the standard of proof in civil cases, meaning it's more likely than not that something happened. It's more likely than not that something happened. For example, in a lawsuit, the judge decides who is more likely to be telling truth. These terms are important. So balance of probability, standard of proof in civil cases, it's more likely than not that something happened. Now beyond reasonable doubt meaning. So beyond reasonable doubt meaning the standard of proof in criminal cases. So that's the civil and that's the criminal cases. Beyond reasonable doubt. The standard of proof in criminal cases meaning there is no reasonable doubt that the accused is guilty. Example, the jury must sure someone committed a crime before convicting them. Now they have a solid evidence, they have a proof, so he cannot deny that beyond reasonable doubt. There is no doubt at all. That's how the crown will prove. Federal Code, the court that deals the cases involving federal laws or the federal government. There are certain boundaries of federal and civil. I'll explain later. At this time, I'll give you a little two or three examples. The case about the immigration or the intellectual property would go to the federal court, and there is some limits for small claim court. A small claim court deal with the civil cases involving a small amount of money, $35,000 or less. So up to 35,000. If it is the case $35,000 and $1, then it will go in higher court, not the small claim court. Up to 35,000. That is very important to understand. Up to, like including 35,000, 1 to 35,000. If it is 3501, then the court will be the higher even after $1. Reference case. Reference case meaning case where the Supreme Court gives an option on a legal question, even if there is no actual dispute. Example, the government asks the Supreme Court if a proposed law would be constitutional. It's just inquiry. It's a case that Supreme Court gives an opinion on a legal question. That's a reference case. Appeal. Next term is appeal as right meaning. Appeal as of right meaning, it's an automatic right to appeal to the Supreme Court in certain cases, like criminal cases where someone was acquitted at trial but convicted on appeal. So at trial he got free, but again convicted on someone appeal. Example: the person convicted of a crime can appeal to the Supreme Court without asking permission. No need to get the permission that I'll go against you for the appeal. Next term is provincial court. Provincial court is the court that handles criminal cases, family law, and provincial offenses like traffic tickets. If you get a speeding ticket, your case goes to the provincial court, not the federal court. Again, the provincial court handles criminal cases, family law, provincial offenses, POA. Now the Supreme Court. Supreme Court is a higher court that handles serious criminal cases, civil cases, and appeals from the lower court. Example: murder trial would take place in superior court. It's more serious. Civil code meaning Quebec, a system of law used in Quebec based on written rules, unlike common law system in other provinces. For example, in Quebec, property disputes are decided based on the civil code, not the past court decision. So in Quebec, a little different. The property dispute is decided based on the civil code, CODE, not the past court decision. These explanation and example are designed to make complex legal terms easy to understand for everyone. Now I'll elaborate a little bit more about how does federalism affect law creation. Federalism significantly shaped the law creation in Canada by dividing legislative powers between federal and provincial government. This division is rooted in the Constitution, which outline the responsibility of each legal government. The key aspect how the federalism affect the law creation. The division of power. The federal government has the power to create laws in certain areas such as national defense, whereas the provincial government has the power to create laws in the areas such as education and health. So the federal government, national defense, it's a more wider area. The whole defense is based, and whereas the provincial government, education and healthcare. For example, Ontario make its own education laws, Quebec make its own education laws. So the constitutional basis, the division of power is defined in the Constitution, and there should be no overlap. One government powers are overlapping other government power, and it just there's some gap in between. So provinces cannot make laws uh, regarding areas under federal jurisdiction, and there are two boundaries: the federal and provincial. They are working as separate. They cannot go intrude in between others. So, for instance, provincial government and provinces cannot legislate on the issue related to national defense. If the area is involved in a national defense, it cannot intervene the provincial government on the national defense sector. Judicial oversight. So judicial oversight is a court can declare a law invalid if it conflicts with the constitution again. So constitution is supreme law. If any law conflict with the constitution, there is no law invalid. Whereas in some areas it's a shared power. Shared power in some areas like environmental protection involved share power between federal and provincial. They share the power and they make it more convincing for everybody. Now the term judicial oversight. Judicial oversight is the court can declare law invalid if it's conflict with the constitution again, and that ensure that both federal and provincial laws adhere to constitutional principles. So delegated legislation. The lawmaking authority can be extended to the other bodies like municipalities through the act of parliament or provincial legislature. Because, for example, the city can pass bylaws about parking rules under the authority of provincial law, as it's working under the provincial government, but it's has some power to make decision regarding parking under the authority, because that provincial body has given the power to make their own small things to act their authority in the particular subject. So I'll elaborate more Canadian Charter of Right and Freedom that safeguard fundamental rights and freedom. As a part of Canada's constitution, the Charter is the supreme law of the land, and the fundamental right, the Charter explicitly protect the fundamental rights such as freedom of speech and religion. For example, if a law unfairly restricts free speech, the court can declare the law is invalid. Protection against discrimination. Charter of Right and Freedom. The Charter also protects against discrimination based on race or gender. And enforcement. If a law says you cannot speak freely, but the Constitution protects free speech, the law can be struck down by the court. But there are some limitations. While the Charter guarantees various rights, these rights are not absolute. There are some limits the government can impose on Charter of Right too. To provide such limits if they are reasonable and justified. There are two conditions. If they are reasonable and justified in free and democratic society, then they can limit. Otherwise, they cannot. Notwithstanding clause. Notwithstanding clause allows the government to temporarily override certain charter of rights. A little bit elaborate the public law and private law again. The public law deal with the relationship between the government and the citizen. Public, always government involved with the government and its action, including criminal law or the constitutional law. That's public law. Example of public law is the criminal cases where the government prosecutes someone for breaking the law. And the public law deal with the matters such as criminal law, constitutional law, and administrative law. A criminal case is an example of public law. Private law. Private law deal with the dispute with the individual or organization, involve relationship between individuals such as contracts or property dispute. An example of private law is lawsuit between two neighbors over a property or boundary, or divorce cases is the example of private law.